Glad you're with us on the Jim Bohannon Show at 1-866-50-JIMBO, 1-866-505-4626, as we're going to be talking in this portion of the program about what might be called Immigration 2.0, the Trump effort to put forward some restrictions on those entering this country, which will pass judicial muster, especially given the fact that the Supreme Court remains a divided court, and that very possibly a battle regarding this could very well go down at 4 versus 4, which would remand it back to the Ninth Circuit Court of Appeals, which is no friend of the Trump administration. Byron Henry is with us. He is an attorney and appellate partner of Scheef and Stone to talk a little bit about the new White House order, which has basically, I understand it will not ban citizens from Iraq in coming to the country. Do you see other major changes?
Yes, Jim, glad to be with you this evening. There's a couple of things that you're going to see with the new executive order, one of which, of course, you mentioned that it's not going to include Iraq in the list of 7 countries that were previously identified by President Bush, George W. Bush, and Obama as countries that were specific concerns with respect to terrorism. It's also going to exclude, which we learned the previous order did from the White House counsel, but it is going to expressly exclude lawful permanent residents or holders of green cards, as well as those that already have visas that they've been vetted and they've obtained their visas from the State Department. Those individuals will be excluded from the so-called travel ban. And with those two groups excluded, those are major changes because basically under current case law and statutes, they're the only two groups that have statutory or constitutional rights if they're not inside the country. Meaning, if you're here, you have certain due process rights, but if you're not in the country and you don't have a visa or you're not a lawful permanent resident, you don't have due process rights outside the country or any statutory rights. So that's going to be a major change and something that's going to really alter the legal case against Trump's executive order.
In other words, are you saying that the basis used by the Ninth Circuit would be short-circuited, as it were, by this? In other words, the Trump objectives would be met, that the basis of the complaint that was upheld by the Ninth Circuit would no longer apply.
Exactly. There was basically all of the Ninth Circuit's opinion were based on cases that basically loosely afforded some sort of process under the Constitution or statute to green card holders or certain people with visas that were out of the country for a very limited duration of time or intending on coming back. So without those two moorings to base its decision on, they are left with the only individuals seeking to enter the country are those that don't have visas, are either seeking refugee status or asylum seekers, and therefore don't have any constitutional or statutory rights, and therefore the vast majority of the opinion will just be basically undercut or short-circuited, as you put it. The only issue remaining that was not addressed by the Ninth Circuit was this argument somehow that by choosing these countries, 6 remaining countries that are majority Muslim, that is some sort of religious discrimination or violation of the Establishment Clause because President Trump and his administration are targeting Muslims for this ban, and that really has not been ruled on by the Ninth Circuit, and that would be remaining. But I suspect that's really the only claim that will be left with any legs, and although I think it's weak, it still will have to be decided under the new order.
Now, looking at the McCarran-Walter Act of 1952, the Immigration and Nationality Act of 1952, this gives broad, I guess you could argue overly broad discretion to the president, but I want to read from this. Whenever the president finds that the entry of aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, the president may, by proclamation and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Now, to me, the wording of that, I'm not a lawyer, granted, but the only way that the Ninth Circuit could possibly possibly attack that language would be to declare the McCarran-Walter Act unconstitutional, which they most definitely did not do. I mean, if you want to argue that that's too much authority, then declare it unconstitutional. But the act gives the president godlike power to make this decision.
It gives the president broad powers, and as we know from the Supreme Court of the United States has said, immigration is one of the few areas where Congress almost has plenary power over immigration, basically the broadest power, and if they decide to delegate to the executive's authority to suspend entry of any class of aliens, I agree with you, and that's why I believe that ultimately this order as it exists, the current order probably would have survived ultimately en banc at the Ninth Circuit or otherwise at the Supreme Court of the United States. That being said, the one issue that was left out there kind of dangling was lawful permanent residents have a special place in the pantheon of constitutional law, and they're not considered necessarily aliens, and because the original order thought that, was thought to apply to lawful permanent residents, those with green cards, a lot of people thought that he was exceeding his discretion by banning green card holders that were outside of the country that wanted to get back in. Under the new order, that will be an issue. So once you take out the green card holders, and he's even gone one step further, he's saying that if you have a visa, someone who has a privilege to have a visa, which, by the way, they don't have a right to a visa, and the State Department can revoke that visa almost at will, he is giving them the benefit of the doubt and saying, if you were granted a visa prior to this new order, I'm going to go ahead and let you come into the country, which, in my opinion, he has no obligation to do. So he's actually extending visa holders that courtesy. But others, there is no way that I can see under any current case law or that statute you just read that the president lacks the authority to ban or to prohibit for a period of time a class of aliens such as refugees, asylum seekers, student visa seekers, vacationers wanting to come to the country to vacation.
I hadn't even thought about the visa holders, which you outlined, but in terms of green cards, was that an oversight on the part of the administration? I mean, when I heard that green card holders were included, I must admit that I thought, how can that be?
Well, first of all, the order didn't say they were included. It could just be read to have included green card holders, and the White House counsel. So
the order was not specific enough.
That's right, and McGann came out a couple days after the order and said it didn't apply to green card holders. Unfortunately, the challengers exploited the ambiguity of the order, and President Trump and his administration are going to fix that in the new one.
All right, we will take a quick break. We're going to come back with more. 1-866-50-JIMBO, 1-866-505-4626. We'll be back in just a moment. Welcome back to Jim Bohannon Show at 1-866-50-JIMBO, 1-866-505-4626. We're talking with Byron Henry, an attorney and appellate partner of the firm Scheef and Stone. We're looking at the new Trump immigration restriction executive order. And let's talk with Vicente in Cedar Rapids, Iowa. Hello, Vicente.
How are you today, Jim?
We're fine, thank you.
Good, good. Hey, I have a silly question. First of all, I am an immigrant. And, but first and foremost, I am also an American. I remember what we went through and what we've been through since the mid-1990s. I remember when I decided to stay here in the United States and got married, when they started the first attack on the World Trade Center. I also remember the Daniel Pearl beheading, James Foley and Steve Sokoloff. I remember all of that, and I believe what President Trump should do is what Abraham Lincoln did. You see, in 1857, when the Democratic-controlled Supreme Court justice decided that in the Dred Scott decision that black people were nothing but property, that they didn't have the same right that white people had, all 3 years after that, Abraham Lincoln was elected president of the United States. And then in 1862, he, issued the Emancipation Proclamation.
Right.
And from that point on, he ignored that Supreme Court justice ruling from 1857. So in the interest of the country, since we have been attacked by a specific group of people that have said that they are going to purposely infiltrate terrorist people in the group of people that are coming to the United States of America in the interest of our national security. Why can President Trump just overrule whatever the Supreme Court justice
all right. Well, let's pose that to our guest. First of all, of course, presidents may not just simply unilaterally overrule Supreme Court ruling. In fact, I suppose short of a different Supreme Court ruling, such as Brown versus Board of Education following Plessy versus Ferguson, I guess the only way to overrule a Supreme Court ruling is through a constitutional amendment, Mr. Henry.
Well, I mean, you can have a constitutional amendment, which has happened a few times in our history, or you can actually, have the personnel on the Supreme Court change.
Exactly,
so
as in Brown versus Board of Education.
But there is analogs, and I'm certainly not advocating this. I'm just pointing out the fact that the idea that the Supreme Court is the final and sole arbiter of all things constitutional is itself a creation of Supreme Court case law, where the Supreme Court actually said about itself eventually that it actually had the final say over what was constitutional. Well, that's not actually in the Constitution, but it's something that we have, through practice, simply abided by, that the unelected, life-tenured judicial branch would interpret the laws, and Congress and the executive branch would defer to the courts and follow the court's ruling in that respect, much like we've had the agreement that when the Congress passes a law, regardless of whether the Supreme Court likes it or not, they're supposed to enforce it and actually, interpret it according to what it says. So a lot of it is constitutional, and a lot of it is through practice through the years, but there is nothing in the Constitution itself that prohibits the president from what you might say so-called challenging a co-equal branch of government with respect to their view on what's constitutional and what it's not. Hopefully we could just have a Supreme Court that follows its own precedent and follows the Constitution strictly and allows the executive to do its role and protect the country, and the Supreme Court tries to stay out of the executive.
Well, now that is an interesting interpretation, and in terms of actual wording, that's very true. I've read the Constitution many times, and it doesn't say so per se. Of course, presidents, even those who have bitterly disagreed with the Supreme Court, have always gone along with what the court has had to say. Doesn't it surprise you that no chief executive has ever followed that particular line of reasoning, unless you agree with Vincente that Abraham Lincoln did just that back in the Civil War?
Well, certainly Abraham Lincoln committed a few acts as executive that any person, any scholar would say historically were extra constitutional.
Like suspending habeas corpus during the Civil War.
Certainly, and the real question is that the reason presidents don't generally defy the Supreme Court is because generally the civil nature of the disputes, such as turning over the tapes in the Nixon matter, President Nixon, or whether or not it's same-sex marriage, or whether or not it's the Defense of Marriage Act, or whether or not it's immigration policy, generally is a civil matter which can be fixed, so to speak, or altered through the congressional process. Meaning Congress can just fix the problem, and we can do it civilly. We don't need to have a president thumbing his nose in another branch because there are mechanisms to deal with it. Unfortunately, because the president is the sole arbiter of the military, the commander-in-chief, and the protector of national security, and the Supreme Court has no role in national security. Of course, protecting rights it has a role, but not in national security. There's really very difficult to fix, so to speak, or to straighten out Supreme Court missteps when it comes to national security, because the president does that, generally not Congress or the Supreme Court. So the only area in which I believe it would even be heard of with respect to defying or otherwise challenging a court ruling would be if it was something that was imminent in the national security, such as the deployment of troops or the launching of a missile strike and things. And those things the Supreme Court shouldn't be involved in the first place.
All right.
Well, here in immigration, we're crossing over both national security and civil policy with immigration, so that's why you get this dispute.
All right, we'll take a break and be back in a moment. Glad you're with us on the Jim Bohannon Show as we're talking to attorney Byron Henry about the revised Trump administration executive order on immigration, and to Laura in Wichita. Hello, Laura.
Hi, how are you?
We're fine, thank you.
I had a question about the law you read that gives the president a very broad authorization to ban a certain class of people.
Right.
It says if he finds that. Now, I'm not a lawyer, but I've worked for lawyers, and that word is very important because it supposes a state of facts, a set of facts that he bases that decision on.
Okay. But, I mean, again, how a president, quote, finds that, I mean, I'm not a lawyer, and we'll ask the lawyer in present here, but again, whenever the president finds that the entry would be detrimental, he may impose these restrictions or any restrictions he may deem to be appropriate. So as I say, that is broad. Now, Mr. Henry, does that word, the president finds that, has Laura found an area that could be a problem here?
Well, basically, with respect to this, both the statute and the order, the word find there basically is the equivalent of determined. So you could read the statute as simply saying if the president determines that a class of aliens, and the caller is correct, that the president needs to make a determination or a finding. The executive order actually has the finding in it.
What are the ground rules for this finding? I mean, the way Laura mentioned it, it sounds as though we can't just simply say, well, I've thought about it, and this is what I find. What are the ground rules under this word finds?
Well, there's two things to think about here. First of all, his determination, his finding is based on his intelligence briefings and information at the State Department, and as we already know, we've discussed, these 7 countries, now 6 that were listed, have all been designated prior to President Trump becoming president as countries with specific concerns with respect to exporting terrorism.
Including by the Obama administration.
That's correct. But the second problem is that when you give a president or anybody the broad discretion to make a determination or finding, that includes with it the inability of another branch or someone else to go behind it and say, we understand you determined that these people are detrimental, but in fact, we don't believe they are, because once you allow a court or Congress to do that, then you're actually saying you, in fact, did not give the president the discretion to determine someone was detrimental. So
making a big deal out of the word fines, in your view, would be a violation of the wording of the law.
Not just that, but it'd also be a interference by the judicial branch into the executive branch, because of executive determination, it's no different than the executive determining that he wants to have a drone strike against ISIS members in a foreign country. He makes that determination based on information that's given to him, and he calls it. We wouldn't, of course, have courts say, we know you found you needed to have a drone strike in Afghanistan, but we're going to actually find you cannot do that.
Got you. All right. To Maggie in Alexandria, Virginia. Hello, Maggie.
Hello. Thank you for taking my call. Thank you. First, I want to say thank you to Mr. Vicente, your previous caller, for giving a good comment.
Yes.
Abraham Lincoln had backbone, of course. Yes.
He did. Of course, the courts later disagreed with some of his application of that backbone, but go ahead.
It worked. Does anybody recognize that if courts, for instance, keep ignoring the sense of the public regarding public safety, that something might happen? I mean, for instance, along the northern tier of the country, the so-called Rust Belt, there are reportedly about 10 million unemployed and underemployed men who can get a hold of guns. And the so-called immigrants and refugees could be picked out by appearance. You see? Does anybody recognize something could be brewing out there? Or somebody might think matters in their own...
Are you suggesting that there's this mass murder of immigrants who look Middle Eastern that's brewing under the surface?
No, not necessarily. But if courts keep ignoring the sense of the people, that maybe some people are dangerous out there and shouldn't be let in here en masse, you know.
Well, all right. We'll put that to Mr. Henry. Of course, the courts have always been somewhat isolated from public opinion, and in fact, by the very nature of the way that the courts are selected, they're usually one or two administrations out of sync with the American voting habits. Your thoughts, Mr. Henry?
Well, certainly that one of the features of the judiciary is that they're not supposed to bend to political or specific, special interest will. But I think the caller makes a very good point that when, the judiciary is very good at carving out exceptions to rules because they know there's certain things they shouldn't dabble in. So the judiciary has created the state secrets privilege, and the judiciary has created for itself the political question doctrine. That allows the judiciary to bow out of certain hot-button issues that they feel that the judiciary is not the best qualified to address. And that fine line is what we're getting into here with the Ninth Circuit's ruling and some of these district judges.
All right. Well, we're going to have to wrap on that note with our thanks to Byron Henry, an attorney and appellate partner of the law firm Scheef and Stone, to talk about the new Trump immigration restriction executive order, noted principally, I guess, for the elimination of Iraq from the list of 7 countries. I'm Jim Bohannon, and this is Westwood One.